Former President Jacob Zuma has agreed to continue his testimony at the State Commission on a date yet to be decided. This after Zuma announced his shock withdrawal from the commission on Friday morning. Zuma's lawyers had argued that he was being unfairly cross-examined. After behind-the-doors consultations, the former president agreed to continue his testimony. The commission had to set the record straight regarding the agreement, emphasizing that there was no deal reached to supply Zuma's team with questions. In a statement, the commission said that areas of interest in a particular witness's statement will be conveyed to Zuma's lawyers within the next 2 weeks. This means that Zuma will be offered the opportunity to supply his version of incidents or events mentioned by certain witnesses in the form of an affidavit. A time frame for Zuma's responding affidavit will then be agreed upon by the respective legal teams. Let's take a listen to Judge Raymond Zondo.
The decision that the former president would no longer participate in the proceedings is withdrawn, and that the former president, I've been told, has indicated that he wishes to continue to cooperate with this commission. And his legal team also wish to continue to work with this commission. It has been agreed that the way in which the former president's concerns may be taken care of is that the Commission's legal team will indicate to his legal team what the Commission's areas of interest are in each witness's statement or affidavit on which the Commission or they would like the former president to testify.
I must thank you for the intervention you made that made the situation to be looked at and arrived at some common point in terms of continuing with the process, as it were. I think it is the right of anyone to raise concerns if there are concerns, and the concerns should be looked at. And I appreciate that you were able to meet the two teams and found the way forward. Because I think it is in the interest of all of us to address issues that face this country in whatever form. And also the clarity of the way forward, as it has been indicated by ourselves here, that there will be work done to allow the smooth process.
So that's what's happened earlier on in the week. Now, in other news, political developments banking group ABSA denying that it refused to cooperate with the public protector, Busisiwe Mkhwebane, with regards to her investigation into President Cyril Ramaphosa. Mkhwebane has said her office had subpoenaed ABSA to provide bank account information relating to her investigation into the president. However, ABSA has denied receiving any such subpoena. Mkhwebane has found that President Cyril Ramaphosa had misled Parliament in response to a question about a 500,000 rand donation from Busasa for his presidential campaign in 2017. To talk more about this issue and other developments throughout the week, political analyst Professor Somadoda Fikeni joins us now on the line. Professor, very good evening to you. Thank you so much for speaking to us. So we've seen President Ramaphosa's office poke holes into the report. What are your thoughts preliminarily on how this is going to play out?
Well, I do think that this particular case will have political undertones either way. And secondly, it will only be decided in the court. And the price will be very high for each one of them. If, for example, the public protector's findings were to stay, the political and the legal implications for the president will be quite severe. But at the same time, if the president prevail in the review process, the future of the public protector might be precarious in a sense that the perception might be, if you add cumulatively other judgments, that she might have overlooked certain things. So for each one of them, it's a do or die situation.
And I'd like to talk about having erred cumulatively, the presidency accusing her of saying, having taken a cursory glance at her report, according to Section 7, subsection 9, the notice which was issued in which she asked for information, it seems that the public protector did not even use the substantiveness of the report that was given by the president. Is this possibly going to be another case where she is found lacking in not only using information before her, but ignoring pertinent information?
Well, if that proves to be the case, indeed, it could be seen as having a predetermined outcome, unless proven otherwise by the court of law. And remember that you also have the review processes of Pravin Gordhan, who also indicated that within 48 hours of submitting the information, there was a presentation on the matter. And as I was saying, the political undertone of these particular cases might simply be, given the preponderance of many submissions to the public protector, which ones could she be prioritizing and which ones could she be pushing back? Those are the political undertones that are going to come, but the legal process of the validity of her approach or otherwise is the one that is going to be more decisive.
Now, just listening to some other analysis, the suggestion seemed to be that the Public Protector's Office has become the battleground for fight for power and legitimacy in South Africa. What are your thoughts on that?
It is inevitable. The stakes are very high. There are two offices now, and perhaps three, which are likely to become battlegrounds precisely because they have the tools to legitimize or delegitimize political leaders. That is the office of the public protector. That is the public prosecution office, as well as the judiciary in its entirety. Because in a democracy and in a rule of law, political parties have now come to use the outcome of those to pursue and fight their battles. And it is therefore inevitable that the will be politicized.
Is it because the office itself, the Chapter 9 institution office, has been politicized as in the office bearer has pandered to those political divisions, or is it the politicians themselves who are using the office? And I ask this having looked at former President Jacob Zuma's post-commission appearance, singling out the former public protector, saying that she emphasized his wrongdoing in the manner in which she acted.
Remember that Tulima Donzela was not exempted from her actions being seen in a political light. And what saved her in some of the judgments would have been the ultimate review process that was judged in her favor, especially on the most significant cases. And it will be the same here with the Mkhwebane. It's a high-risk game. You take a chance if the big case, especially against the president or a significant minister, goes in your favor. Then indeed, people would say you are doing your work. But if it goes against you and the legal process begin to poke holes, then you will be exposed in a sense of being seen as getting into the political space.
This perceived deficiency in factuality and law, is it something that is a matter of interpretation?
I do think that it could be the matter of interpretation. Remember that even the initial public protector Tulima Donzela's, remedial actions were subjected to the review process. That's when the Constitutional Court guided the process. But now you do have yet another, which says, do you wait for the remedial actions, for the review process or not? And that in itself could just be as technical a legal matter, because generally in law, you would not implement any particular judgment if there was an appeal. If then the court say, in this particular case, you'd have to make an exemption, I think it would need a legal interpretation.
Now, we also saw that legal wrangling over what was supposed to happen at the Commission of Inquiry into State Capture, with the former president appearing, his legal team objecting, saying that he's been subjected to cross-examination, then pulling out, but then coming back on again. Some have interpreted this as the former president really enforcing his political power. What are your thoughts of those developments?
But remember that the biggest challenge we have in the South African context is that political leaders try to solve legal problems politically. And as such, they deploy a political strategy. And one of the reasons for that is because the legal technicalities are often used as a yardstick as to whether one is wrong or right, instead of the ethical consideration of whether certain situations are wrong or right, whether one is found guilty or not. That, to me, I do think that we will continue to see the political strategy and the legal strategy being fused together. It's similar to the situation where the notion of political conspiracy has been used and overused in the South African context, precisely because it's very hard to prove a conspiracy. It's very hard to disprove a conspiracy.
So speaking of that, just how tactile has the former president, being he in his last address to his supporters, even conjured up the name of the former SABC Secretary General Chris Hani, how he was almost assassinated, saying that somebody sold him out. How tactile has his whole testimony been, including naming people like Mwako Ramaphosa and accusing them of being spies?
Well, I do think that the one issue of spies and the naming of people as spies is the most bizarre situation in this case, because either you had a catastrophic failure of ANC intelligence, which would have allowed the same individuals to work in sensitive spaces such as O.R. Tambo's office, to work in sensitive spaces such as military operations, whilst they knew them, and also to allow them to rise politically within the country. Imagine if Nyanda knowingly, if we say, suppose that claim was possible, being allowed to head the most powerful institution, the South African Defence Force, whilst knowingly knowing that he is a spy. It would be bizarre. And never mind that they were then appointed by the former president to his cabinet. They were invited to be part of his political campaign. But the moment they turn against him, it's when we are told something doesn't add up on the issue of spies. And besides, in South Africa, the use of the notion that so-and-so is a spy has been so generously applied. Some have said Mandela was a spy. Some within the PAC used to say the entire ANC is in the payment of foreign, agencies. Some have said Jacob Zuma. Some have said Thabo Mbeki. Some have included any other name, Steve Biko, Sobukwe. None of the leaders, Peter Mokaba, have been spared of this. And it would actually be interesting, as some are saying, de Klerk supplied the information of people who were spies. Can you rely on your enemy to tell you who was a spy without having a thought that this could also be a disinformation campaign to cause discord and mistrust within an organization they were fighting against anyway?
Thank you so much for sharing your insights. Political analyst Professor Somadoda Fikeni.